Yeah, the topic today is on a motion to dismiss in a quote-unquote trial court. There's a lot of people out there who believe that that's a general appearance and thus a stipulation, quote-unquote, to the jurisdiction of the quote-unquote court. For quite a long time, I believed that myself. I don't anymore. And one of the reasons I don't is, and by the way, there's a big case on this that you've never heard of, and it's right out here local to me, and the archive is right here. I'm going to get down and research it and see what I find. Case is called, what did I just say, Lloyd versus United States, out of the Federal District Court in San Francisco, 1928, 90 years ago. And they had tentatively held that an appearance by an attorney would in fact be a stipulation to the jurisdiction of the court because you're asking them to do something they have the power to do. The case was held up for a decision pending at that time in a case called Ford versus United States, 273 U.S. 593. And the Supreme Court more or less confirmed what the district court had concluded, that in fact that would be a general appearance because an attorney is also an officer of the court and gives them jurisdiction. Okay, so far so good. Where I differ though is that number one, when we make motions, we are not making them with an attorney or an officer of the court who could easily be construed to be an officer of the court and jurisdiction attaches. I believe I can beat that claim, but that said, we're doing it ourselves. Number two, much more importantly, is that, and you'll learn this in my constitutional defense document package, you can request information on those at youwinincourt@gmail.com. Be happy to send you information. But the big deal here is I can prove, and it's crazy as it's going to sound, trust me, it isn't. I don't say it if I can't prove it. That Congress now, and for quite a long time prior, and I'm talking over a century here, has not had any members in the Senate or any members in the House of Representatives. The Senate goes back to at least the 17th Amendment, which was purportedly ratified in 1913, which ostensibly changed the way the Senate was selected. It used to be that the state legislatures had the sole entire power to do that. But the 17th Amendment changed it to where senators are popularly elected. The House of Representatives goes to the issue of ratio of representation. And as I love to say about this one, simple as 1, 2, 3. Because Article 1, Section 2, Clause 3 limits the maximum amount of racial representation to one representative for every 30,000 people, inhabitants. Now, at the moment, we have over 300 million of those. If you do the math, you're going to come out to find, as a fourth grader would readily understand, what we should have in Congress is over 11,000 representatives, not 435. And this has been true as far back as 1913 when they passed the damn Federal Reserve Act. At that time, they would have needed about 3,300, and they still only had 435. And not only that, all of those members of Congress then and now had to declare under penalty of perjury that they owed their citizenship to Section 1 of the non-existent 14th War Amendment. Now we're getting into some really serious areas here. For that reason, it's been stated, and by a powerful constitutional authority, Justice Joseph Story, who served, if you don't know, 34 years on the Supreme Court, and at a time very close to when the nation and republic was established, and he was very familiar with all that went on in Philadelphia and was an expert on it. And he concluded, and the Supreme Court has concluded, in the one case they decided on this question under Article 4, Section 4, where the federal government guarantees to the states a republican form of government, that's a political matter left to the discretion of Congress. They have the power to look into that. Well, I'm not sure if I agree with that, although in 1852, when this case was decided, you could make that argument and do it seriously. But now, when I can prove, and I'm not making it up here, I've got a 73-page brief on admission of new states, that there are nobody in the House, nobody in the Senate. Congress is thus without any authority at all, particularly in the area of guaranteeing Republican form of government to the states. Guess what? Who has it? We do. We do. The lawful de jure, jus sanguinis state citizens, aka members of the sovereign body politic of the nation and republic, aka beneficiaries of the trust known as the United States, and aka to at least the FBI these days as domestic terrorists. We are the ones that have the power to do that. And that's exactly what I'm attempting to do by helping people, in addition to our unlimited power to contract that comes from Article 1, Section 10, or is secured by it, of the Constitution, to try and go into court and do that and say, wait a minute, this is all wrong, we can prove every bit of it. And that's one area. So if we're doing that, and we're doing it by making a motion which might otherwise be a general appearance, that can't be true, because this would distinguish that decision the court made in Ford that I told you earlier, and make our case a separate case deserving of a different outcome. And if the justices decided it honestly, it wouldn't even be close, because none of these issues were before the Ford court when they made that decision, even though they could have been 90 years ago. They will be in the cases that I present. And that's where the risk versus gain for us in our favor comes into massive play against these bastards, because they can't risk going to trial and or to the 904 and getting a decision on the record on any of the issues I advocate. Brings down the whole system. It's just how it works and how it needs to work. So that's why they're going to probably go to the settlement table, sit down, get the checkbook out, see you later. That's the strength and power of what it is I do. And it all comes down to a simple issue like a general appearance in court with a motion to dismiss. It's just the proper perspective you have to understand why this is, you can do it and what it means. And that's what you will learn from me, getting my document packets, studying them, teaching your children. That's the whole point, is to keep that going with other generations and keep these bastards from doing it to us again. Continuing with the motion to dismiss that we've been discussing, it's another decision of the Supreme Court that a lot of people think is controlling here, and it's called York versus Texas, 137 U.S. 1. It's a case where a defendant in a civil case who was domiciled in, I think, Oklahoma, but it may have been Kansas, but in any case, not in Texas, appeared in a Texas court to challenge the case that had been brought against him. And he said, wait a minute, you don't have any jurisdiction here. And the case went all the way to the Supreme Court, and they ruled that, in effect, had he not gone into Texas to challenge the service of process, he would have been right. Once he appeared in a Texas court, and I think by an attorney, if I'm not mistaken about that, that's a general appearance. He submitted himself to the jurisdiction of the court, and that's the name of that tune, judgment affirmed. That's how crazy this crap gets at times. But yeah, that's a biggie that's in support, and I agree that it's in support of it. But again, just as I can do with the Ford case, we can distinguish this one too, so that it doesn't apply to our case, which is based on completely different constitutional principles. So that said, just more food for thought. Thank you.